here. The President, please be seated. The President, the court is now back in session. The Defense Counsel may now resume his oral statement. Thank you, Your Honor. I would like now to continue my oral submission. We would like the bench to review Article 99 of the previous Penal Code. Acts are not considered criminal offenses when they are ordered. Based on the 1956 Penal Code, only the person or the entity who ordered shall be punished. For example, Son Sen, who ordered Dutch to commit those acts. And number two, I would like also the chamber to consider the same 1956 Penal Code of Article 238 and Article 24 of the Penal Code of 2009. It means only those who ordered shall be punished and not the perpetrators. The 2009 Penal Code Article 24, person shall be responsible for criminal action for which he or she commits. The acts that Dutch committed was not of his own initiative. They were from his superior. And in between 1970 to 1975, the U.S. President Richard Nixon, who ordered the bombing in Cambodia by the military commander Clayton Abrams, and the order was from the authority of the U.S. presidency. And it means that he knew the act was wrong, but he had no choice but to drop those bombs, to follow those orders. So, therefore, the one who issued the commands shall be the guilty one, not the one who committed the act. And another point, that is from 75 to 70, from 17 April 75 to the 30th of March 76. Within that period, Dutch was at Omlang. And when he entered Phnom Penh, he was the deputy chief of prison. For that reason, he did not involve in the establishment of the prison. And at that time, he was at Omlang and he was not aware of the evacuation of people from the city. He was at a lower rank, as I stated earlier, and from the 30th of March 76 to the 6th January 79, please review the document 00003136 of the Office of the Co-Prosecutors, and the document is in the case file. It has a list of the names of the senior leadership of the Democratic Cambodia and those who were most responsible. So they were the leaders, the senior leaders of the Democratic Cambodia. The document is the decision of the Central Committee, and with the list of the names of those who were the members. And they were the leaders who lead to the killing. And then for those who were most responsible, what are they? The names are listed there. The 7 persons ordered 4 groups of people to commit the act of killing throughout Cambodia, that is, the decision to kill inside and outside the rank. Within the framework of the basis, the Central Committee shall decide. And how many zones? There are 7 zones. And within the 7 zones, was Dutch amongst those zones? No. S21 fell outside of those 7 zones. And for the second group, it meant in the area surrounding the office shall be decided by the office of the center, that is the office 870. And Dutch did not work within that office. And for the autonomous zone, how many? They were Kampong Saum, Siem Reap, Previhir, and Udaminjay. That's the autonomous zones. Dutch was not within that zone. And for those autonomous zones, the Standing Committee shall decide. And for the 4th groups, therefore the Central Army, and who would be the General Staff? That would be Son Sen. Dutch did not have the authority to issue any decision. He only received the order from his superior. So that is a critical document. It has all the names of those people for the categories I just mentioned. So I please urge Your Honor to review the document in order to determine who were the senior leaders and who were those most responsible for the crimes. Dutch was not one of them. Also, I would like to urge Your Honor to enforce the new article of the Constitution, that is Article 129 new, which states that the trial shall be fair and regular, and it shall be conducted in behalf of the Cambodian people based on the existing law and procedures. Fair justice shall be done based on the procedures, and Article 12 of the agreement between the UN and the Cambodian government clearly states to that effect that the Cambodian law shall be used, because this is a national court, it is not an international court. Therefore, it has to use the domestic law. And the existing law, as I said, there are a number of existing laws, that is, our penal code, the criminal procedure, the law on the outlawing of the Khmer rules, the Paris Peace Accord, etc., and etc. There is no need to refer to the international law. That is my appeal to Your Honor. That is based on the interpretation of Article 129 new of the Constitution. And I would like to urge Your Honor to set aside the judgment in case 001 and to acquit Dutch. And number 2, I would urge Your Honor to consider the detention of Dutch is a form of protection for a potential witness in identifying senior leaders of the Democratic Cambodia and those who were most responsible for crimes. And finally, I would like to give the floor to my colleague, to Mr. Kong Ratiri. Kong Ratiri. Good morning, Mr. President. Good morning, Your Honors. I would like to apologize to the families of the victims who were victims at S21. I stand here today not to hide the heinous crimes committed at S21. And even if I want to hide the crimes, I can't do it. And I hope right now here, everybody knows about the crimes committed at S21. I am standing here as a defense lawyer through my full capacity to defend my client based on the law, on the Universal Declaration of the rights, political and civil rights. And I can assert that my client does not fall under the jurisdiction of this chamber, of this court. I am here in order to make sure that my client enjoys the full rights accorded to him, and also to provide legal assistance to my client. I will try to do it to my best capacity in order to make sure that the Supreme Court chamber will use this forum not for political vengeance or to lend a hand to the ECCC to make a political cleansing. And I thank you for that. Based on the agreement between the UN and the government of Cambodia, the ECCC was established to prosecute, to bring to trial those who committed the crimes, war crimes, and genocide and grave breaches of the Geneva Convention of 1949. The agreement is to find justice for the Cambodian people, for reconciliation, peace, and to respect the sovereignty of Cambodia. In the preamble of the agreement between the UN and the government, as in the decision of the Security Council, it expressed the concerns in relation to the grave breaches of the Cambodian law and for the crimes committed between 75 and 79. The concerns led the Security Council to issue its decision number 57/228, recognizing the concern by the Cambodian people and the government in finding the justice and for the stability and peace and sovereignty of Cambodia. And that is the official recognition of the concerns expressed by the Cambodian government by the United Nations. That is the proper recognition as the first step for the establishment of the ECCC. And also it's stated in Article 1, it means that for the concern of the Cambodian government of Cambodia in being to trial is stated in Article 1, and the establishment is the achievement between the UN and the royal government of Cambodia. And that is expressed in Article 1 and 2 of the law of the ECCC law on the restriction and on the authority of the ECCC. Article 2 of the agreement and Article 1 and 2 of the ECCC law, the ECCC is empowered with restrictions on the jurisdiction for the prosecution. ECCC has the power to bring to trial for the crimes, for the war crimes, genocide, crimes against humanity, and the grave breaches of the Geneva Convention of 1949. And the ECCC has the power and authority to bring to trial for the crimes committed within the period of 17 April 75 to 6 January 79. And 3. The ECCC has the power to bring to trial and prosecute for crimes committed within the territory of Cambodia. And number 4, the ECCC has the power to bring to trial those senior leaders and those who were most responsible for crimes committed. During the controversial hearing, the defense team raised the issue of the personal jurisdiction for the accused Kang Gek alias Dutch, and that they shall review and examine the evidence in relation to the Articles 1 and 2 on the ECC law. And Judge Cartwright also accorded to the assertion raised by the defense that Dutch had no authority on the decision to kill those people who were found to be committed in the secret document dated 30 March 1976. And the identification of the document was already provided by my colleague. So it means that he did not have the most responsibility for those crimes committed. And that is also stated in the judgment in paragraph 397 to 99. Also, the request by the defense team to review the personal jurisdiction, it clearly states that there is ample evidence that the trial chamber did not have the jurisdiction over Dutch, but they failed to examine those evidence, and the trial was subsequently concluded. The defense team also tried again in their closing argument, appealing the bench to examine those exculpatory evidence on the issue of jurisdiction based on the spirit of the establishment of the ECC and the ECCC law. Once again, the trial chamber fails to examine the exculpatory evidence requested by the defense team and the opinion of Judge Cartwright, and as a result, on the 26th of July 2010, the trial chamber pronounced a judgment in case 001 dated 18 July 2007 finds Kangkei Alice Dutch guilty for the crimes committed at S21 under the direct supervision of Son Sen, the General Staff, and he is convicted to a single sentence of 35 years of imprisonment. Based on the notice of appeal against the judgment dated 26 July 2010 of the trial chamber, in that, the defense team argues that the conviction made by the trial judgment is wrong, as Dutch failed outside the jurisdiction of the ECCC. And we also provided the following arguments. One, that is on the error of the jurisdiction, of personal jurisdiction by the trial chamber. The trial chamber extend its authority, expanded outside the Article 1 of the agreement and Article 2, 1 and 2 on the establishment of the ECCC law, so that Dutch would fall under the jurisdiction of the ECCC, despite the document dated 30 March 76 on the decision to smash inside and outside the rank. Dutch was not within that structure or hierarchy, and based on the report by the expert Greg Atchison, who works for the Office of the Co-Prosecutor, Son Sen had the direct decision to make, and Pong and Lin was the one who was in charge above Dutch. Under the General Staff of the Ministry of Defense, for those who were arrested and sent to S21. Those arrests were made after the decision made at the Central Committee. The trial chamber fails to properly examine the personal jurisdiction as stated in Article 1 of the agreement and Articles 1 and 2 new of the ECCC law, and against the customary law that was used in Tokyo as well. In Nuremberg and Tokyo trials, the court did not prosecute those who were the soldiers of the allied, even if they knew that they committed the same crimes as the enemy in Europe, and for the war criminals, because of the restriction of the personal jurisdiction imposed upon those courts. And there is no person who were leaders at the lower level were prosecuted. Only the senior leaders who committed those crimes, or the military generals who were prosecuted. And the court itself is not allowed to expand its authority in order to prosecute the Allied soldiers, or to bring to trials for those soldiers, even if they committed the same crimes, even if some were more serious. It means that in general the court had to abide by the jurisdiction set upon them. They could only charge those who were within the jurisdiction, even if other people committed the same or more serious crimes. However, at the ECCC, it acts contradictorily. It did not have any evidence to link to Article 1 of the agreement or Articles 1 and 2 new of the ECCC law on the issue of the jurisdiction of my client. Also, the ECC also relied a lot on the jurisprudence of the ICTR and ICTY on the jurisdiction in regards to the subject matter, but not on the personal jurisdiction. It means the statute of the ICTY and ICTR are not similar to the ECCC law. The distinction is the restriction of the personal jurisdiction. At ICTR and ICTY and Nuremberg and Tokyo, there was no restriction on personal jurisdiction. In fact, in ECCC there is sufficient and ample jurisdiction, and there is no need to refer to other law or jurisprudence. If it is needed, then it has to be consistent with the existing law and legal instruments in Cambodia based on the agreement in Article 1 between the UN and Cambodia. The use of other international law is only to complement the lacunae in the domestic existing laws or the laws at the ECCC, and they have to be consistent with the ECCC. The system used in the ECCC, which is a sovereign state, is the priority. As we all know, ECCC is not an independent court like an ICTR or ICTY. This is a domestic court. So it is within the territory of the country which utilizes the civil law system. The use of the common law system by the trial chamber is a distraction of the civil law system that is currently used in the state, which the ECCC law falls under, and which set out in the agreement between the UN and the in the government of Cambodia. ECC shall use a complete civil law system. Therefore, the principle of legality shall be respected. Based on that, it shows that the trial chamber violated Article 2 new of the ECC law, that it expanded its power beyond what is set out in the law. The use of the international legal instrument is not appropriate because the jurisprudence of case law is to be used only when it has to examine in details for the crimes committed. That is the first option, and the second option is to examine the legal system which is in existence, whether it is parallel or consistent. And the third point is in order to determine whether there is a lacuna for the judgment that is issued based on the options 1 and 2 above. ECC restricts the personal jurisdiction, which is not the same as the statute of the ICTR, ICTY, the Nuremberg or the Tokyo, as personal jurisdiction is not considered. But here, they are set out clearly in the ECC law. The trial chamber failed to examine and review these 3 points, which were taught clearly in any law school throughout the world. The civil law and the common law system are not the same. And for the judge to interpret a law based on the civil law system, we all know that the judge cannot create a law by himself or herself and cannot expand the authority of the law by himself or herself as well. And this practice has been taught in the legal law, that a judge cannot expand his or her authority, and that also is applicable only to the common law system. ECC is within the sovereign states that use the civil law system. This has been expressly reflected in Articles 13 and 12 and 13 of the agreement between the UN and the government, and Article 5 of the Cambodian Penal Code. Article 12 of the agreement allows the ECCC to apply the Cambodian law, and only where there is a lacuna in Cambodian law that guidance may also be sought at the international level. This means that one cannot seek any international law unless the above situation prevails, otherwise it is in contradiction to the Cambodian law. The excessive application by analogy at the ECC runs counter to Article 5 of the Cambodian Penal Code. It can also be viewed that the ECC, by following the common law tradition, proprio motu expands its jurisdiction and arbitrarily adjudicates cases. It means that they have to look also at the evidence filed and submitted by the defense team. Also, the new documents that we submit to the Supreme Court chamber, the documents that we receive from DC Camp, that is F14.2.4, ERN 00626210, that is the selected 31 biographies of Khmer Rouge leaders and others. And they made a conclusion for those who shall be prosecuted. The assertion that Article 1 and 2 new of the ECC law is not clear is not appropriate. According to Rule 87, the judges shall examine the evidence and to use his or her profession before a person can be charged under Articles 1 and 2, and also Article 28 of the new Penal Code of Cambodia defines the person who would be the perpetrator or is the instigator. That is, those who gives an instruction to commit a felony or misdemeanor, or provokes the commission of a felony or a misdemeanor by means of a gift, promise, threat, incitement, coaxing, or abuse of his her authority or power that is consistent to the decision dated 30 March 1976 of the Standing Committee, as my colleague just read earlier.
The decision actually determined who issued orders and who shall be responsible for the crimes, or most responsible for the crimes. And for that reason, we should not resort to other criminal laws to interpret such a case. We only need to look at the law available before us. An instigator shall only be liable to punishment if the commission of or attempt to commit felony or misdemeanor is established. Articles 1 and 2 of the